Assalamualaikum warahmatullahi wabarakatuh. To our beloved lecturer, Sir Ashraf bin Saimun. My name is Muhammad Tidalaikal bin Tahir. My metric number is BA24110033. And today I will share regarding pregnancy and maternity leave in the Sabah Labour Ordinance All Amendment. In the All Amendment, maternity leave are offered to the female employee that are pregnant for 16 days for each delivery. Secondly, in the All Amendment of Sabah Labour Ordinance, employee must have worked for the employer for at least 19 days in the 9 months prior to delivery. And the third All Amendment in the Sabah Labour Ordinance is the rate of the maternity allowance, normal rate of daily salary times of the day of the leave, or the rate are set by minister. And the last thing in the All Amendment of Sabah Labour Ordinance regarding pregnancy and maternity leave are the female employee that are pregnant cannot work for 14 days before the confinement, and they cannot work 44 days after the confinement. That's it for me. Thank you.
Assalamualaikum warahmatullahi wabarakatuh. My name is Sakira Marquez Media Abdullah, room address BA24001016. Today I will presenting section 83, pregnancy and maternity after the amendment. The section will specifically protect the female employer to receive 19 days of paid maternity leave subject to certain conditions. Where the eligibility condition is that the employer must have worked to the employee at least 19 days or within for 4 months before the childbirth, and also she cannot take the maternity leave more than 5 times throughout her period of employment with the same employer. The employer also receive employment protection. That means the employer cannot terminate her during her maternity leave except for a reason misconduct or company closure. In addition, about recurring salary payments, the employer is entitled to receive full wage throughout the maternity leave period subject to eligibility condition. If a female employer receive a monthly salary and that salary is not conducted during her maternity period leave, she is considered that she has already received a maternity allowance. A female employer may return to the work during the maternity leave period. She can back to the work with the employee concerns and also with the health certification issued by registered medical practitioner. I think that's all for me. Thank you.
Assalamualaikum, my name is Muhammad Hamzan Syami bin Abidin, BA 24110577. I will explain about the discrimination in employment. Previously, there was no special section to explain discrimination in employment. However, Section 118B states that the director may investigate a complaint if a resident employee claims to be less fortunate than a non-resident employee in terms of employment. There was also a prohibition on dismissing resident employees under Section 118C only to replace them with non-resident employees, so the main focus of the discrimination in the old version was related to the status of employees, not discrimination on various other grounds such as gender, race, and religion. That's all from me. Thank you.
Assalamualaikum everyone, my name is Sofian Rasinda binti Sapri and my matrix number is BA2411034A, and I will now present the section 18 discrimination in employment, which will be focusing on what has changed after the amendment. After the amendment, Section 18 has been significantly strengthened to provide much broader and more comprehensive protection to employees. The amendment was introduced to ensure that all forms of discrimination in the workplace can be properly addressed, investigated, and resolved. One of the most important improvements is that the Director of Labour now has the authority to inquire into any employment dispute that involves discrimination, regardless of the type or category of discrimination. Previously, the law was limited because it focused mainly on discrimination between resident and non-resident employees. However, after the amendment, the law now recognizes that discrimination can occur in many different forms. This means that if an employee faces unfair treatment based on their gender, their race, their religion, their age, marital status, or what kind of unfair treatment they faces, the director is now legally empowered to investigate the case. This creates a more inclusive and fair working environment where employees feel protected and supported. Another major improvement relates to enforcement and penalties. Under the amended section, if an employer refuses to comply with the decision made by the director after an investigation, the employer may be charged a fine of up to 50,000 ringgit. This is a substantial penalty designed to ensure that employers take discrimination cases really seriously and do not ignore directives from the labor authorities. Other than that, the amendment introduced the possibility of daily fines if the offence continues after conviction. This means that for every day the employer fails to comply with the director's order, an additional fine may be imposed. The creates strong pressure for employers to correct discriminatory practice quickly and responsibly. The introduction of this penalty shows that the government aims to strengthen accountability and prevent employers from engaging in actions that unfairly disadvantage certain groups of employees. Overall, the amendment makes the enforcement process clearer, stronger, and more effective. In summary, the amended Section 18 provides a clearer investigative procedure and stricter penalties for non-compliance. This helps create a workplace environment that values fairness, equality, and respect.
Assalamualaikum and good evening. My name is Luqman Hakim bin Jafaruddin. My matrix card number is BA24110327, and I want to present about the arrangement, flexible working arrangement, section 120. Before the amendment, the standard working hours were allowed were 48 hours per week. At that time, there was no clear provision in the ordinance regarding the procedure for employees' right to apply for flexible working hours. In addition, the existing regulation stated that an employee may not work for more than five consecutive hours without being given a break or at least 30 minutes. In terms of daily working limits, an employee may not work more than 8 hours per day, and although certain exceptions may apply, the absolute maximum permitted was 10 hours per day. That's it for me. Thank you.
Assalamualaikum and good evening. My name is Rizal Nalif bin Ahmad Saleh, and today I will present my part, which is flexible working arrangement. Okay, but I will present after the amendment. After the amendment, working hours are reduced to 45 hours per week. In section 120A and 120B, employees can apply for variation in working hours, days, or place of work. The application must be in writing in a form prescribed by the Director of Manpower or JTK. the employer must give a decision within 60 days, and if rejected, the employer must provide a written reason.